Well, happy Friday and welcome to TuckerAllen Live on Facebook. It's 1 o'clock Central and I'm Scott Trout here to moderate the short period we're going to have with Jim Gow. Welcome, Jim, of TuckerAllen.
Thanks for having me again, Scott.
Yeah, thanks for joining on this Friday. As always, we want to bring you some information about estate planning, and today is unique in that we want to talk about generally you thinking about, I have a will, I have a trust, I want to plan for beneficiaries, the complicating factors of perhaps a beneficiary who may have a substance abuse problem. And that really creates an opportunity to be a little bit more specific, but also have to do some really good planning. So as we're going along, if you have questions, I'll be monitoring Facebook. You can go ahead and submit your questions in the comment section, and we'll try to get to those today in the short period that we have you. If you have any questions, you can go to TuckerAllen.com. You can always schedule a consultation right there on the website. You don't have to pick up the phone. You can select the office you're interested in, and you can select the time you want to come in. So Jim, this is, I was kind of reading through some of the notes. It really is unique and requires individuals to really think about it. I mean, they're stressed out enough dealing with perhaps a close beneficiary who's really struggling with some substance abuse issues. And now you want to layer on top of that, not only dealing with the now, but how do you deal with the then in the future? And what happens perhaps if you have money, that becomes a problem. So I mean, start off the bat, a will is just not going to cut it, I imagine, in this circumstance.
Yeah, so the main thing people think of when they come in, and obviously families with substance abuse problems, they kind of know it's there, but it's not necessarily the first thing they bring up in an estate planning meeting. So a lot of people come in and very typical, they'll just want to know, okay, how do I get my stuff to my beneficiaries and avoid probate, not have to, get it all tied up in the courts. And, you do that with normally a will-centered plan, which does have to go through probate, but then with beneficiary designations, kind of piggybacking on that, because those beneficiary designations will avoid probate. The issue is those beneficiaries take a life insurance policy, for example. You set your life insurance to be your 3 kids. All the 3 kids are going to do is fill out a beneficiary claim form at your death, send it into the insurance company with a death certificate, and the insurance company is just going to write 3 checks for a third of the money to each of them. Now, if one of those kids has a substance abuse problem, we've got an issue because now they've got a stack of cash that they can either go out and buy, alcohol or drugs or go gambling with it and spend it all. So, it's not just substance abuse; it's any kind of addiction issue. That's the issue there.
Yeah, I was going to say I can think of a whole host as you were talking about it of concerns. I mean, I know we're talking about substance abuse, but you can think about immaturity, inability to handle money. You mentioned gambling, any kind of issues in which just say you have any cash, you drop that amount on a young adult who may just not be ready for it. They just may blow it all. And I mean, so I think that this topic can be larger than the substance abuse, but clearly the most important is trying to prevent and fostering what already is a real issue. So I guess then that brings in, what are your options to try to help plan for your beneficiary to try to make that when they do inherit that a little bit easier and more manageable and more planned?
Yeah, so the good thing about estate planning is that you've got your powers of attorney, which are the basic documents that say, this is the person to be basically my guardian. You've got your will, which, as I mentioned, has to go through the court. You also have a really handy tool, a revocable living trust. And so that's kind of the main document most people use for their estate plans nowadays, regardless of total net worth. And it's for reasons like this. It's not just, so when you set up a lifetime trust, they're called, for beneficiaries. The main goal of that, when I do the planning and we talk through it with clients, is asset protection for those beneficiaries. And when people think of that, they think of, oh, well, if they get sued or divorced, it's protected. Yeah, it's protected for them, but you can also set it up so it's protected from them. And so what you would do in your revocable trust is, if there's a beneficiary that's going to have this problem, or has a very high likelihood of past abuse issues and potentially recurring abuse issues, you put in their lifetime trust that it goes to this child, but I want my other children, or I want aunt or uncle, or I want a corporate trustee to be in charge of that money, so that they can't simply go to the bank and and raid the trust coffers and run to Vegas or run to the bar or run to wherever you buy the drugs. Yeah, I mean, that's kind of the first stage of getting this planning done is get it incorporated into your revocable trust.
It comes to mind, and it's not necessarily equivalent to what we're talking about, but you're thinking about someone who may or may not have mental health, substance abuse. Britney Spears, it's in the news. She has this money in a conservatorship. It's probably in a trust, and someone's managing this money. The theory being she's not capable or qualified or competent to handle that. Now, whether she is or isn't the issue. But it just came to mind as that's just a great example. Perhaps I'm thinking of maybe of a child who is an adult but just isn't ready, or maybe they do have a drug issue. Can you imagine getting a $100,000 life insurance policy and boom, it's in the account, and what they would do with it if you really felt that they weren't equipped to do it? I mean, that's the point. Is it's probably you're so stressed out dealing with it. You want to ensure that, as you suggest, I want to avoid probate, but you're not thinking about what you can do to really help them in the future, which is really amazing. And you talked about a corporate trustee. It takes maybe some of that. I can see that taking that relief away from a family member having to deal with that, because I get at first, I guess, glance, that beneficiary may be angry that you've set it up in a trust. You don't trust me. Well, no, I just want to provide for your needs long term. Maybe that's the way you say it.
Right. And in the trust terms, you can build in, and usually this is where it's most successful, is you build in what I call incentive provisions. You build in provisions into the trust that rewards them for seeking help or getting the recovery they need and the treatment they need. And so you build in provisions like, if you go to AA twice a month or once a week, then you can have $1,000 a week or something, something
Right.
along those lines, where it's just encouraging them to get the help that they
Yeah.
need.
Go get your 4-year degree. Yeah. Complete rehab, whatever it is, created. And this is just another instance where you want to work with a certified financial planner. This money's going to go somewhere. You want to invest it appropriately. Someone's managing that money and making sure that, it's, can provide, as you suggest. So, gift trust, what is that?
So the gift trust is, so we mentioned the revocable trust and building in, provisions for after your death. Well, the gift trust kind of steps that up to the present date. So you set up the trust now and you set aside money for this beneficiary that may have, and you can do this for every beneficiary, but specifically for this discussion, set that money aside for the beneficiary that has substance abuse problems. It gets it out of your taxable estate. It sets it aside, it exempts it from your creditors or divorcing spouses and things like that. And it's also going to do the same kind of things that the revocable trust does after your death, but it does it now. You can set aside money now. So if they're in and out of treatment, maybe it's good to set some money aside now out of, that you're going to use for him or her, and put that money aside now in an irrevocable gift trust.
So I think you mentioned creditors. Will it be protected from the child's creditors too?
Correct. Yeah. So it's essentially, so when you set up a revocable trust, when the grantors die, the creators of the trust die, those trusts become irrevocable. All you're doing is setting that irrevocable trust up now, as opposed to creating it when you die through your revocable trust. And the good thing is, with retirement accounts and life insurance policies, a lot of the times the financial companies are wary of making the beneficiary on a policy a trust created in the future. But if you create this irrevocable trust now, it gets its tax ID number, and then you can actually set that to be the beneficiary of retirement accounts and life insurance policies, so that those are also insured and guaranteed to be protected for the beneficiaries.
So I've been reading a lot about what is to come with the Biden administration messing around with the death tax and the taxable administration, the estate level, whether it's going to go way down to $1 million, whatever it is. Does setting this irrevocable trust up help in terms of some tax planning if you were to do that?
So what it will do is, right now the estate tax exemption is $11.7 million, and it's portable between spouses. So for a married couple, you might as well just call it $23.4 million. what happens when you gift to an irrevocable gift trust is that is technically, if it's over the 15,000 annual exemption that you can gift tax free, that is, so let's say we gift $100,000 into this irrevocable gift trust for the benefit of our substance abuse, beneficiary. That is technically a taxable gift in the year that it's gifted. So in 2021, you would have to file a gift tax return, but it's not taxable and there's no tax due if you claim it against your lifetime exemption. So what you would do is you'd gift $100,000 over to this gift trust, tell the IRS, hey, I'll just take 11.6 million of my exemption when I die. You can use 100 now. And so it takes advantage of the high estate tax exemption now, especially given that we know at least it's going to go down to half of it in 2025. And who knows before then or after then what's going to happen.
Right. So talked about a last resort. You could just stick with a revocable trust, I imagine.
Yeah. So kind of the last resort. So a lot of the times clients will set up trusts and then they'll go 5-10 years, which we do not recommend at TuckerAllen. You need to come in at least every couple of years and revisit your estate plan. We even have a whole program for it called our Legacy Protection Program.
Yeah. But I think I've mentioned that once or about a dozen times.
maybe a baker's dozen. Yeah. But some clients will set their revocable trust up and just say everything goes to my 3 kids equally, and they won't touch it again, and they'll end up passing away. And it's just a generic trust that says lifetime trusts for my 3 kids, no special, provisions in there for special needs or substance abuse. So what you need to have at least at minimum in your revocable trust is a catch-all override provision for special needs, substance abuse, or underage or incapacitated beneficiaries. So what those provisions say is essentially ignore everything else my trust says for this beneficiary. He's got a substance abuse problem. Hold the money for his benefit. Do not let him pull it out whenever he wants, however he wants. Basically treat him as though he's special needs beneficiary.
So in the last minute or two that we have, if you have a client, someone's listening or watching right now, they're thinking, okay, sounds great, but I don't want to do any of that. What else could I do that's outside the box? Something that is, not nearly as an intelligent, planned role that you described, but there's still options.
Yeah, so the outside the box things are things that, you hear clients talk about all the time when they're talking about planning, and it really does go, the conversation kind of goes the way that you just described it. It says, yeah, that sounds complicated. I'm not doing that. What do I do now? So what are my options? And one the clients come up with a lot is, I'm either just going to gift the money to one of the substance abuse beneficiaries' brothers or sisters, and they're just going to take care of it. You hear the same kind of thing when older clients just say, I'm just going to put my kids on the account and we'll be fine. Well, so what you're doing there is you're trusting one of the children or 1 or 2 of the children to inherit money that's theirs legally, and then spend it, gift it every year to their substance abuse, beneficiary that who knows if they're close with the family members anymore. They may have gone, on their separate ways and maybe estranged a little bit, but you're trusting one child to take care of the other child. And it's just really not a good idea for practical reasons as well as tax reasons, and just that's causing a rift between your children.
Yeah, I can't imagine putting them in that spot. That's the whole point of being deliberate in the trust, that you don't have to worry about this infighting.
Yeah, and it gives, even if you're putting that same child in charge of as trustee, at least the trustee then has the fallback of, well, the trust says I can only do this. Yeah. It's not, you're holding $100,000 of my money, give me my money. That's right. That's what happens when you gift that money outright to one child. And the other option is just disinherit the child completely. But you can imagine that's just going to make the substance abuse problem worse when your parents die, you're grieving to begin with. And then the trust says, I'm disinheriting my child for reasons they should know. It's not going to help. And so that's obviously, not the best solution either. And it's not helping them get better, which I think is the goal of a lot of clients.
No, right. The outside the box doesn't seem like something you want to explore. It is the last absolute option. And I think, as you described, if you've got someone who perhaps they just have a will or they don't have any estate planning, these are just minor additions with great planning to already an affordable estate plan. So
Right.
thanks, Jim. This is great stuff for those. I mean, again, it's not just substance abuse, drug, whatever it is, alcohol, gambling. I just see this application for anyone who says, look, my kids are just not mature enough to handle. You may have a couple 100,000, you may have 1 million, you may have whatever. That's a lot of money to hand off to a 20-year-old child or 21 or 24 or, something else. So thanks for joining, Jim. Really good.
No problem.
Well, continue to tune every Friday, 1 o'clock Central Time. We'll bring you information just like this over 15 minutes, just a great power packed 15 minutes. Always tune in to our virtual town hall. We have one coming up in July. You want to look out for that. You can get information. It is free. All you have to do is register. You can attend, you can log in, and you can ask questions live of the panel of the Cordell and Cordell attorneys, just like Jim. He mentioned the Legacy Protection Program. I always got to throw that in because I'm always enamored by it. You want to find out more information, you can go to the website. You can get more information about the Legacy Protection Program. You don't have to be an existing TuckerAllen client to get that security blanket. So again, you can also schedule a consult by calling or just doing it on the web, TuckerAllen.com. So see you next Friday, 1 o'clock Central Time, same place, same time. Have a great weekend.